Good morning. My name is Alan McCoy. I'm Director of Startup Support at University of Maryland's Ventures. I'd like to extend a very warm welcome to everyone who joined us today for our next installment in Startup Fundamentals Workshop Series, both live webinar audience and those watching a recorded version on our StartupUMD YouTube channel. This workshop series is offered by Ventures at the University of Maryland. To everyone attending the live session, please feel free to submit questions using the Q&A function at the bottom of your screen. Since we're recording this session, there is an ability for you to submit your question anonymously if you would like to do so, but you don't have to. So today's session will cover, is part 2 session about practical considerations for intellectual property. It will cover IP basics. Today's speaker, welcome Greg Tinch. Greg is also an entrepreneur like many of you who are joining us today. Greg is managing his own firm, and he holds a mechanical engineering degree from the Ohio State University and a Juris Doctor degree from the University of Maryland School of Law. So he is practicing law right here in our backyard. Greg has a wealth of legal training and experience, ranging from federal legislation and policy to civil trials to patents, trademarks, copyright, and trade secrets. Thank you so much for your time and expertise to discuss such an important topic with us today. I'm gonna let you take over the microphone. I'm gonna turn my mic off and my camera off and let you take over the session. In the meantime, I will be monitoring the Q&A session, the Q&As. So anybody has any questions, please feel free to submit them throughout the session. All right, thank you. Mic is yours.
All right, thanks, Ala. Hello to the assembled webinar attendees. Good morning. My name is Greg. I'm a business law attorney. I run my own firm called Tinch Law Firm PC. I'm actually based out of the UMD Discovery District. I work out of the WeWork when I'm in the office. Today I'm not in the office, but you can find me there. My practice, well, the part of my practice that's relevant for today is I support pre-seed seed stage companies with patent, trademark, copyright procurement, and really leveraging federal law to enlarge your intellectual property rights and also to protect your rights. Yes, so this is part 2 because part 1 was a little content rich and just ran out of time. So we're back to do it again. But this time I'm going to, part 1 talked a lot about like business structure, business law kind of basics, business entity considerations. So in this presentation, I'm going to focus more on intellectual property assets like patents, trademarks, copyrights, a little bit on trade secrets, and also some considerations for contracts and chain of title ownership type issues. Oh. So that's intro slide. Uh-oh, hold on. Here we go. All right, so topics today. All right, I'm losing control here. Let's just move straight to patents. So, I'm going to kind of structure my discussion around each asset on subject matter eligibility or just general eligibility, the process of like the procurement process for each asset, and then just some general high-level considerations. If you have questions, just feel free to drop them in the chat. And I put some kind of like off ramps throughout my presentation so we can just have a discussion and talk about the questions as they may arise. So patent. Um, Patents cover any new and useful machine, process, article of manufacture, or composition of matter. My background's in mechanical engineering, so I do mechanical, electromechanical inventions, and also design patents. I don't do a lot of software, but I know the law around software, and I don't do plant patents at all. Those are like biotech patents. That's outside of my expertise. So the subject matter eligibility. So we're really talking about like physical goods that exist in the world, and they have to have some new inventive aspect to them for patentability. So in addition to the machines, the processes, the articles of manufacture, there's some judicially created exceptions. And the one to really be aware of is subject matter, is abstract idea, the judicial created exception for abstract ideas. So this is, if you hear people talk about like software patents being difficult to procure, this is why. The law is a little bit complicated around when an abstract idea is patentable, whether there's like enough of an inventive aspect around the abstract idea for it to be patentable. So the procurement cost for software patents is generally a bit higher than for the other patents. In addition to subject matter eligibility, the other patentability requirements are novelty. That means, is it new, as in, did another invention claim the exact same subject matter that your disclosure claimed? And then the other piece that really adds a layer of complexity is obviousness. So not just did, you write patent A, the examiner cites in their office action patent B, which claims like part of your claim. But then they could also say, well, in view of patents B and C, which you claimed would have been obvious to someone that had skill in your area. So that's just, it's going to take too long to go through all the law, but I just want you to like have an idea of what you're looking for when you're applying for a patent. So we've gone through subject matter eligibility. There is, there's two kind of species of non-provisional patents. Those are the patents that give you a patent certificate at the end and the actual asset. So there's utility patents, which are like the patent for the way your phone works. The patent on the semiconductors in your phone, or the patent on your computer processor that makes your computer go. And then there are design patents. Design patents like the shape and design of your iPhone, assuming you have an iPhone, smartphone. So a design patent covers the ornamental features of an article of manufacture. Utility and design patents are both non-provisional patents, but they cover different, they have different scopes. A design patent has one claim, whereas a utility patent can have a bunch of claims. Most have 20, but you can pay more and incorporate more claims into your disclosure. For utility patent, if you ever seen a patent, it's the 10, 20 page patent with the drawings and the long written description. A design patent, by contrast, is pretty short. It's probably 1 or 2 pages, and the drawings, like 1 or 2 page written disclosure, and then the drawings. And the scope of a design patent is really defined by the pictures, the drawings, whereas the utility patent scope is defined by like what the language of the claims is, and the drawings help flesh out the scope of the claims. So quick, oh, what happened? Sorry. Quick overview of the process. So I would recommend, if you have the budget, to do a pre-filing patent search. That will, I talked about the patentability requirements. So subject matter, the search isn't going to help, but it will help you identify other disclosures that may implicate the novelty or the obviousness of your invention. And it's not to say don't file your patent, but it is to say you can draft claims to hopefully avoid the other disclosures that the examiner may be inclined to cite. So pre-filing search. Then the second step is to file your application. The components of the application, there's a written disclosure piece where you just disclose everything about your invention that you believe is new and explain how it works so that someone having skill in your area to duplicate it. You have your drawings. The drawings are required if the drawings help to explain like any claim that's not just, they help to explain your claims and how you would make and assemble your products. And the last piece is, there's some formalities that the PTO has published. There's an application data sheet. There's an information disclosure statement where you disclose other patents or non-patent disclosures that may implicate your invention or that are close to that are related to your invention. Application, then prosecution. The prosecution is the phase where you negotiate with the patent office to determine the scope of your claims and the scope of what patent the examiner will allow. And then there's post-allowance, which is after your patent is granted, you will have maintenance fees due at certain intervals specified under federal law. And also, you can make the calculation around whether it's even worth it to pay the maintenance fees. Like if your invention hasn't been paying the returns that you thought, maybe it doesn't make sense to keep paying the maintenance fees. But in any case, maintenance fees are due for a non-provisional patent over the 20 years term. Considerations. So you only get to claim one invention per patent. If you have a broad disclosure, if you have like a really inventive invention, and let's say you disclose like 3 patentable aspects, the office will likely say, hey, look, you can only have one invention per patent. So they will issue what's called a restriction requirement. And they'll say, okay, you got to pick one. There's more than one. You have to pick one. So you'll pick which invention you want to go forward with. They will examine it. And you won't lose the other 2. You have to file what's called a divisional application to claw back the other patentable aspects that you weren't able to claim in the first in the parent application. Design patents. Design patents are effective. They're the procurement cost is lower, but keep in mind, Apple and Samsung were involved in litigation, and Apple actually won $533 million in a jury verdict for a design patent infringement. That was actually the most valuable claim that they made in that litigation over the utility patent infringement. So don't just disregard design patents. And, we talked about patent search. If your budget allows, I think it's helpful, but not, especially for startups and entrepreneurs, you can't always budget it. But if you can, I think it's helpful. And don't forget this, I will try to sprinkle this throughout, is your fees. The fees for IP procurement and to maintain your IP portfolio are tax deductible. So yes, there's an upfront cost, but you will get a tax benefit for making the investment. Checking my notes. Oh, last thing, US is a first to file system now. So get the earliest filing date that you can to maximize your rights and the scope of your claims. You can file what's called a provisional patent. Provisional patents do not become granted patents. However, they do preserve an earlier filing date for you. They're good for a year. So if you filed a provisional today and tomorrow, tomorrow IBM files a patent that mirrors all of your claims, you later file a non-provisional that claims the filing date of the provisional, you can beat out the IBM claims because you have an earlier filing date. So I just put on this slide, first in time is first and right. You don't have to take copious notes. I will coordinate to send these slides out. That's no problem. So with that, I think this is my first off-ramp for questions, if there's any questions.
I don't see any questions submitted, but if anybody would like to raise the hand and ask question that way, please do so. Or if not, we can move on to the next topic. I don't see any questions.
Okay. Then I'll move on. So part one, I covered trademarks. I think I got all the way through my trademark slide, but I'll recap that just briefly. But I wanted to talk about copyrights because I don't think I fleshed that out during part one. So copyrights protect your original work of authorship fixed in a tangible medium. So what are some examples? You can copyright software. Software actually has dual patent and copyright subject matter eligibility. You can copyright architectural drawings. You can copyright music and movies, obviously. So any original work fixed in a tangible medium, as soon as you reduce it to the medium, your work is copyright eligible. The term of a copyright is the life of its author plus 70 years. And the scope is what you actually created and also derivatives of that work. So like the Fast and the Furious franchise, the Hobbs and Shaw offshoot of that franchise is also like subsumed within whatever's, I think, Paramount's copyrights. And work for hire. So if you hire a vendor to create something, the copyright law makes you, the employer, the owner of the copyright and not the vendor. So if you hire someone on Fiverr and they create some copyrightable work for you, keep in mind that you own it. You shouldn't have to have a dispute with that vendor. Another issue, so process. You register your copyright with the Library of Congress. It's not the USPTO. the Library of Congress actually registers copyright. So the process is there's an online application available. There's lots of tools on the website is copyright.gov, and there's a lot of tools for self-filers. So there's not like video tutorials, but there's a lot of written materials to kind of walk you through the process. There's an online application, you fill it out, you can e-file it, and you have to file, in addition to your registration application, you have to file a deposit, which is a like sample copy of the work that you're copywriting. The deposit becomes part of the Copyright Office's record. Actually, you can make an appointment to go to the Library of Congress and review different deposits from that form other copyright registrations. So, you know, if you're based locally, that's kind of one nice thing that you can do if you, or let's say you get a cease and desist letter, somebody's complaining that you are infringing their copyrights, you could actually go there and take a look and make an evaluation for yourself. And if you electronically file your application, the processing time per the Copyright Office is about a month, 6 weeks. And the electronic filing fees are about between $45 and $65. So it's very accessible cost-wise. That's the slide. Considerations. One important consideration is if you are collaborating with co-authors, every co-author on a registration has an undivided interest in the whole thing. So if Ala and I co-created a movie, Ala could go sell the movie without my permission. She could sell the copyright to the movie without my permission. If you want to divide up the rights, or if you want to have one collaborator have complete ownership, you need to execute what's called a collaboration agreement with your co-author. So it's kind of like, I don't know if anyone owns a house, but if you do, if you own it with your spouse, then if I predecease my spouse, then she owns the whole thing. And if vice versa, if she predeceases me, she will own the whole thing. Whereas if I just owned a house with my brother or my cousin, then, you know, I would have half and they would have half. This is kind of like the collaboration is like with your spouse. They can completely dispose of the asset without your permission unless you have the collaboration agreement. Next consideration, if you get common law copyrights as soon as you create the work. However, if you want to sue under federal law, so there's basically enhanced damages, significantly enhanced damages under federal law. If you want to have the right to sue under federal law, you can either pre-register your work, so you can file the copyright registration before you publish, or register within 3 months of publication. But that's how you avail yourself of the full force of the Copyright Act. And I already mentioned that software and patent has concurrent subject matter eligibility with between copyrights and patents. So, you know, the pros and cons, I think the patent pros are your protection is broader because a patent gives you the right to stop others from making copies, and also the non-obvious improvements of those copies, or no, copies, non-obvious improvements, and functional equivalence. So it's just a broader scope of protection. copyright has a slightly narrow scope of protection. So it's not just your exact code, but it's also derivatives of the code. So, if a competitor just changed a couple lines, I think legally that's still copyright infringement, but it's not as broad as a patent's protection. But conversely, copyrights are cheaper procurement. They're faster if you procure them online by a lot. And the subject matter eligibility, like the law around subject matter eligibility and patents right now, will drive up your prosecution costs. So mainly the big difference is price, procurement cost. And that's all for that one. So next, off ramp here for questions, if anyone has questions.
I don't see any submitted questions. Again, offer for you would like to raise your hand and ask a question that way, we can. But don't see any raised hands, so we can move on to the next topic. Thank you.
Okay. Next slide. I wanted to quickly recap trademarks. Like I mentioned, I think I covered trademarks pretty fully during part one, but I think probably, well, every business that's trying to distinguish itself in the marketplace has a brand and therefore has IP that's probably eligible for a trademark. So a federal trademark registration, you can get a trademark registration in Maryland, or you can get a federal trademark registration. The benefit of the federal registration is you get priority to that brand, that mark, in every US jurisdiction instead of just your state. So if I had a state registration, then if somebody in California decided they were going to use my mark, I would be protected around here in this region, but I wouldn't be protected for any infringement in California. But if I had the federal registration, everybody in every US jurisdiction is on notice that this is my brand. And if you infringe, you had notice that I was using this brand. So that's the benefit of federal registration. The subject matter for a trademark. It is inherently distinctive marks that distinguish your goods and services in the marketplace. It can be a logo design. It could be just words like McDonald's, I'm loving it. It could even be a sound like the Southwest ding. There's a trademark registration on that. There's other versions of trademark protection that are probably beyond the scope of this talk, but they accrue after time, like 5 years or so. There's what's called trademark trade dress protection. It protects the packaging. So the Coke bottle, for example, there's a trademark trade dress on that, but you have to establish a secondary meaning in the marketplace, or just like a strong association with your goods to get that. So it's not ripe right now, but just keep it, or it's not ripe for startups, but keep it in mind going forward. Trademark is an asset that's issued by the US Patent and Trademark Office. And the term of a trademark can be indefinite as long as you keep using the mark in commerce. You keep your trademark registration active by filing renewal affidavits between years 5 and 6, or affidavits of use between years 5 and 6, and then you renew your trademark every 10 years after that. So post-registration, not a lot of filings do, but it can last forever if you keep up with the filing schedule. Next slide. Quick overview of the trademark process. It's similar to patents in some ways, at least like timeline wise. So I typically I recommend a clearance search to see whether there's a different brand that may be construed as confusingly similar to your brand mark. The PTO has a database of every trademark. It's searchable now. It's not as robust as like a Google search, but it is searchable. Um, there's some kind of tools and tricks to get relevant hits back, but I recommend at least doing a search in the trademark database. Then if you come up with a filing strategy that you're happy with, you move forward to the application phase. So um, the most cost-effective route is to file a electronic application with the USPTO. It's called a TEAS Plus, or what's TEAS stand for? Trademark Electronic Application System. You file an application via that system. There's an online application form. You file it. The filing fee is $250. Then your application is going to be pending for probably 9 months or so. Then a trademark examiner who works for the USPTO will look at your application. They'll decide whether your mark meets the legal requirements for a trademark. And then assuming it does, you get the trademark registration. If not, then you're in what's called the prosecution phase, where you negotiate with the attorney assigned to your case about whether your application did in fact meet the legal requirements for a trademark registration, or whether you have to make some changes to get your registration. And then, like I mentioned, there's the post-registration renewals between years 5 and 6 and every 10th anniversary. And according to the data published by the PTO, the total pendency for trademark applications is running about 14.3 months. So a little over a year, give or take. Some additional considerations for your trademark application. So when I search, I'm looking for, first before the search, I'm trying to make an assessment of whether your mark is inherently distinctive. So what you can't register is a descriptive mark. So if I had a tobacco shop and I called it the tobacco store, that would probably be rejected as descriptive because it just describes the nature of the goods that I'm selling. But if I called my store maybe the smokehouse or something like that, then that is suggestive, and suggestive marks are registrable. They're not the strongest marks, but you can get a registration for them. I'm also looking at the search phase to determine whether there's any marks that are confusingly similar to your mark. So there's a legal test, of course, to determine likelihood of confusion. But if you see a mark that conjures your own mark, then I think should be at least a yellow light, and it's worth investing a little bit further. And then you're also required to be using your mark in commerce to get a registration. So you can file your application based on your intent to use a mark in commerce. So that means, I think timing wise, if you're preparing to launch a brand, but you're probably like 6 months to a year away, then I think it's fine, or really 14 months, it's hard to guess that. But if you're about a year out from launching your brand in commerce, then you're good to file that intent to use application. just so that you can get the earliest priority date. Similar to patents, you need to beat out your competitors as far as like first to the market. So, or first to have protection for the brand. So the earliest filing date you can get will be the most beneficial for your brand. There is, like, process-wise, if you file an intent to use application, your application is examined like a mark that is actually used in commerce, but you have one extra filing at the end. You have to file an affidavit that says, I was planning to use the mark, now I'm using the mark in commerce. Here's an example. And then you get your trademark registration. Now, in rare cases, you can get, I'll say the trademark law office still holds the right to issue a rejection based on the specimen. So it's probably worth having a consult with an attorney just to line everything up before you file the specimen, but that's a pathway for you to safeguard your rights and not get beat out by a competitor. Another kind of like asterisk for the search. So after your application is examined and the trademark law office approves it, it is published in a USPTO publication called the Trademark Official Gazette. Any member of the public who thinks they might be harmed by the registration has the right to file what's called an opposition. It's a litigation proceeding in a PTO tribunal, but the thing to be aware of is it is, as opposed to the trademark law office, which is not self-interested. It is a self-interested person making a self-serving legal argument, and it's full-on litigation. So if you litigate that case to the end, it's probably going to be on the order of $100,000. Now, I would say an attorney could file something into the case in the early stages to hopefully get it dismissed, but just be aware when you search, if you see like a Fortune 500, 100 brand that has something close, even though it may not meet the legal test for confusion per your analysis, I think there's always some risk that the big brand could file an opposition just because they have the money to do it. And another application consideration is, file the 1B to protect your mark, but just know that you can't make any material changes to your app once it's filed. And the material changes, the examiner will say, it's one that triggers me to search again. If I have to search again, that's a material change, and you can't make it. So you can't like add new descriptions of the goods and services, and you can't change the mark. You can't change the description of the mark, but you can't change the mark itself. It's kind of in stone when you file the application. And some post-registration considerations. We've already been over the years 5 and 6 and a year 10 renewal. Monetizing your assets. So I was going to mention that later, but just a quick statement about monetizing your assets. Usually the route to monetizing IP assets is assignments and licenses. They are contracts that transfer some or all of your rights in your asset, either like forever or for a fixed time. And in the case of a trademark, I don't think licensing makes sense because there's this idea of trademark dilution where, if someone blurs the lines of where your good or service comes from, It's a different theory of trademark infringement. You're diluting my brand because people are a little confused about the source of goods. So, you know, I don't think a license makes sense because you are authorizing someone else to use your brand. And I think that kind of necessarily confuses the source of goods and services. But um, there's an alternative called a concurrent use agreement. So that's where you and the another brand can agree that um, both brands can coexist in the marketplace peacefully and no one's gonna be mad at the other for infringement. Um, and then also just a quick nugget, there's a mechanism to protect your trademark internationally. A registration filed at the PTO level protects you in all US jurisdictions, but if someone in China infringes your mark, then you wouldn't have any recourse under US federal law. But there's this treaty called the Madrid, I think it's called the Madrid Protocol, but you can file an international trademark protection and get trademark protection in jurisdictions outside the United States. It's still worth being aware that even if you have that registration, if you want to sue in a China court or a Ukraine court, you would likely need a China or Ukraine attorney, and you would have to bring the suit there. But it is an option for protecting your IP rights abroad. And with that, next off ramp for questions.
I don't see any submitted questions. So if you have a question as Greg is talking and describing things, please feel free to ask them. If not, we can wait until the end and open up floor for people to unmute their mics and ask them that way, or keep submitting questions. So I don't see any hands raised or questions, so we can move on to the next topic.
Okay. So this is my last section. I just wanted to throw out a couple considerations that I hadn't covered in much depth yet. So we'll just run through those quickly. Trade secrets. So I didn't put a section dedicated to trade secrets because they are the outlier for they are different than the other three, as there is no trade secret application. A trade secret is commercially valuable information because it's secret. The group of people who know about it is limited. So, the recipe to Coke, maybe a client list, or if you had some like proprietary system for, generating leads and conversions, that might be a trade secret. To prove trade secret infringement, you need to be able to prove that you had that secret and that you also took reasonable steps to protect the secrecy of that secret. So reasonable steps are, password protecting your files and gaining access to the files, and having having employees sign non-disclosure agreements or non-compete agreements. So they agree not to just, if they're separated, to go and call your clients and try to get them to jump ship. And I just, when I was researching, I found I just wanted to give a quick case note. There was a case in 2022 where Ford worked with a software vendor who had given them software to prevent like recalls of their cars. And they worked with this vendor for years. And then After like 5 years, I think, canceled the license and deployed their own software they alleged they made internally, but the software company sued them for trademark infringement and won like $106 million verdict, but the the trade secret infringement damages were 22 million for trade secret appropriation. So it is worth just taking the precautions to, if you do decide, instead of going the copyright patent route with your software, if it's just a secret, that's another mechanism to enforce your IP rights. Just be aware. And then I wanted to just talk about contract considerations that some came up earlier, some didn't. So in part one, I talked about the importance of organizing an entity. I think it is important for, you will commonly hear attorneys say, for tax reasons, and also for liability reasons, your entity will be liable instead of you yourself being personally liable, like you, the individual, being personally liable. Also, your entity can own IP assets, and I think that piece is useful if you are, if your company is a target of an acquisition. I think the acquirer will certainly want to see a clean chain of title in their due diligence process. There are companies that employ some kind of like crafty ways to keep their liability down, or their tax liability down. They like license a asset between different entities within the same umbrella. So there's a lot of reasons to organize an entity and transfer your IP to that entity. HR policies that are worth having. You should have every employee sign an employment agreement or an employee agreement that transfers any IP that they make within the scope of their job duties back to the entity. And then also, you should have the founders execute an assignment as well, because founders separate from the ventures that they start, but you don't want them to leave and take their ideas with them. Another consideration for the employee agreements is that there's kind of a legal fight around whether, we've all been hearing about AI lately. So there's some legal movement around whether an artificial intelligence can be an inventor on the patent. As far as I know, it is limited to human inventors. So that means that, either employee or founder or some vendor will have created this IP. So for the company to have rights and not for the inventor to have rights, who's the de facto rights owner, you need to have these contracts in place to get the title back to your entity. And then for trade secrets, I talked about the non-disclosure and non-compete agreements. So these agreements will help make your case. If you have to sue under the federal trade secret law, they'll help make the case that you took reasonable efforts to protect your proprietary information. Sorry, just looking at my notes. And then I just had this recap slide of the ideas, like the hopefully the big takeaways from our discussion here today. So again, talked about the entity in part one, but it's really important for you to have an entity really for liability purposes. Also, if you have to go to court, your entity can sue in its own right. But if you know, if you invent something and you invent a lawnmower and somebody like pushes the lawnmower and cuts their foot off, if they sue you if they sue you personally, then you're on the hook for whatever the judgment is. But if they sue your company, your entity, then your liability stops at the assets of the entity and you are not personally liable. So it's important if something goes wrong, heaven forbid your business goes bankrupt, but it won't bankrupt you personally. Second, the assets themselves, the trademarks, patents, and copyrights, and trade secrets. But I think they are useful to, helping your company build market share, but also you can sue others for infringement. You can get some big judgments, even for the lowly design patents. So we saw there's a judgment for, $500+ million for design patent infringement. You're maximize your rights by getting the earliest possible filing date. So that is provisional applications for patents. That's 1B applications for trademarks if you're not selling a good in commerce yet, or if your brand hasn't launched quite yet. Just remember that your investments in your intellectual property assets are tax deductible. So make sure your bookkeeper, accountant is aware. They draw down your revenue, so they'll decrease your tax liability. And from a contracting standpoint, at least to keep the chain of title for your entity's IP clear, you should just have like standard IP assignment clauses in your employment agreement with employees and also in the founders agreement. They should be assigning their assets back to the venture because they do leave. I've seen situations where the founders leave. So you don't want them to take your profitable assets with them. And that's it. If there's more questions.
Well, thank you. That was that was a really great overview, and I like all of the practical advice that you have from the point of view of helping actual startups. Anybody has any questions, please submit them or raise your hand to ask them. We have about 4 more minutes left in the session, so if you have any questions. In the meantime, just from your work with companies, with startups, can you name some of the most common IP mistakes that companies make that you see that you have sometimes to help them and sometimes maybe difficult to help them?
Yeah, the co-authorship, the collaboration agreement for copyrights, that was an interesting realization. But if you're, I think it's pretty common for people to just like not co-collaborate, but it's also common to co-collaborate. So that is a good nugget to be aware of. I talked to some founders that were surprised that you could file a trademark registration before you were actually using the mark. So I wanted to, bring that to the fore. And yeah, just from part one, I have a small litigation docket, but I just wanted people to be aware that your, you are not your business. So if your business employs people and people have like, family issues, they have like personal things, and the party on the other side may ask your business for something in the discovery phase of the litigation, but don't panic. Also, don't ignore it. You can talk to an attorney and figure out how to handle it, but you really have to be mindful that you aren't your business. So, just because you have something doesn't mean you have to turn it over. You don't have to give up your business's like proprietary information. I I think entrepreneurs have a like mindset of either I substantively can just do this myself because I'm a self-starter and I'm smart and I'm determined, or they just also may think like I don't have the resources to hire an attorney, or I can't do this, I can't do that. But I think it is worth um, trying to find a way to get a consultation and get a second set of eyes. Or if you have an organization, there's other officers, ask them what to do. Don't just like rely on your own thoughts. If you can like stress test your ideas with other people, that's helpful.
Mhm. Thank you. That's a great perspective, especially since that's something that you actually dealt with in your daily interactions with local startups. So it looks like we are at time. If anybody has any questions, you can follow up with Greg. There's his contact information, his email address, and his Calendly link as well, or feel free to reach out to me as well. We will be posting this session on our StartupUMD YouTube channel, so you can review it as well. Again, thank you so much, Greg, for spending your time with us and sharing your wealth of knowledge on intellectual property protection for startups.
Thanks for having me.
Thank you. Have a good day.
All right, you too. Good luck, everybody.